Question number 801. Intentional insult with intent to provoke breach of peace is punishable under section 504 IPC. Question number 802. A. For the purpose of inducing B to desist from prosecuting a civil suit threatens to burn B's house. What offence was committed by A is guilty of? Abetment, criminal assault, criminal force, criminal intimidation. Correct answer is criminal intimidation. Question number 803. False statement, rumor, etc. circulated with intent to cause mutiny or offence against public peace is dealt under section 505 of IPC. Correct answer. Question number 804. Which one of the following provisions of IPC punishes to misconduct in public by a drunken person? Correct answer is section 510 IPC. The minimum duration of imprisonment provided for an offence under IPC is 24 hours under section 511. Yes, this 24 hours under section 510. Sentence of 20 hours under section 510. Sentence of imprisonment till rising of the court under section 511. Here the correct answer is 24 hours under section 510. This is the minimum duration of imprisonment provided under IPC under section 510. Question number 806. For which of the offence last section of IPC makes provision for punishment? Abetment to commit an offence, attempt to commit an offence, planning to commit an offence, preparation to commit an offence. Correct answer is option B, that is attempt. In section 511 of IPC, attempt to commit an offence is provided. Question number 807. Which one of the following is an inchoate offence? Options are public nuisance, criminal attempt, unlawful assembly, riot. Correct answer is option B, that is criminal attempt. Inchoate offences are incomplete offences. Question number 808. Doctrine of locus potentia is a doctrine invoked in cases of obscenity, rape leading to offer of marriage, attempt, exploitation of theory of punishment. Correct answer is option C, that is attempt. Question number 809. The punishment for attempting to commit offence punishable with imprisonment for life or other imprisonment is provided under section 511, under section 509, section 510, section 507. Correct answer is option A, that is section 511 IPC. Question number 810. The section 511 IPC is not applicable to attempt to commit suicide, attempt to commit rape, attempt to theft. Here the correct answer is option A, that is attempt to commit suicide. Question number 811. Section 511 IPC does not apply in cases of attempt of theft, affray, riot, murder. Correct answer is D, murder. Question number 812. Which one of the following statement is not correct with regard to the nature of criminal attempt? Options are: criminal attempt is the direct movement towards the commission of the offence after the preparations are made. Criminal attempt is an intentional preparatory action which fails in its object, an act which is done intentionally in attempting the commission of an offence. And option D, when commission of an act done intentionally is successful, it is criminal attempt. Correct answer is option D, that is when commission of an act done intentionally is successful, it is criminal attempt. Question number 813. Preparation and attempt are two stages of commission of crime. Preparation is not punishable generally, but attempt is. One basic reason as to why preparation is not punishable is that there is no nexus between preparation and attempt. Can be chances of change of mind before commission offence. Is absence of intention, is absence of attempt. Correct answer is option B, that is can be chances of change of mind before commission of offence. Question number 814. Under IPC, preparation to do a criminal act is an offence, not an offence only in respect of certain criminal acts, none of the above. Correct answer is option C, that is an offence only in respect of certain criminal acts. Question number 815. In which of the following section of IPC preparation is punishable? Options are section 121, 125, 398, 122, 125, 399, 122, 126, 399, 121, 126, 398. Correct answer is option C, that is section 122 of IPC, 126 of IPC and 399 of IPC. Attempt to commit an offence is punishable with, options are half, 1/4, 1/3, full. Correct answer is half. Question number 817. Section 511 of IPC applies to offences punishable under the IPC, any special law, any local law, all of the above. Correct answer is option A, that is IPC. Question number 818. Section 511 of IPC does not apply in case of attempt of rioting, attempt of theft, attempt of waging war against the government of India, attempt of affray. Correct answer is option C, that is attempt of waging war against the government of India. Question number 819. Which one is not a theory of attempt for section 511 of IPC? Options are proximity rule, theory of impossibility, object theory, Durham theory. Correct answer is option D, that is Durham rule. Question number 820. X applied for the post of lecturer in Delhi University and submitted his application along with degree of PhD. Interview call was issued to X on 2nd February 1992. Was the date fixed for the interview of X? But on 10th January 1992, the university came to know the copy of degree attached with the application was bogus and cancelled the interview. Here, X is guilty of cheating, X is guilty of attempt to cheat, X is not guilty of cheating because the university has not been cheated, none of the above. Here correct answer is option B, that is X is guilty of attempt to cheat. Question number 821. A woman ran to a well stating she would jump in it, but she was caught before she could reach it. She is guilty of attempt to suicide, attempt to injure herself, attempt to culpable homicide, no offense. Correct answer is option D, that is no offense. Question number 822. A see B drowning but does not save him. B is drowned. A committed. Here A committed, no offense. Question number 823. A intending to commit theft enters the house of B at night and removes from one of the rooms a box to the country yard where he opens it. He does not find in the box anything worth taking and leaving the box there goes away. In this case, A will be liable for the house trespass and attempt to commit theft. Question number 824. A makes an attempt to pick the pocket of B by thrusting his hand into B's pocket. A falls in the attempt in consequence of B's having nothing in his pocket. A is guilty of attempt to theft. Question number 825. A makes an attempt to steal some jewels by breaking open a box and finds after so opening the box that there is no jewel in it. He has committed the offense of attempt to theft. Question number 826. Which one of the following is an illustration of criminal attempt? Options are: A tries to kill B by witchcraft, A goes to Mumbai to buy dye to make counterfeit currency notes, A intending to kill B fires at B's coat hanging in his room treating it B, A takes away his own umbrella thinking it to be of someone else. Here the correct answer is option C, that is A intending to kill B fires at B's coat hanging in his room treating it B. Question number 827. A picked up a revolver and believing it to be a loaded, pulled the trigger with the criminal intention of shooting B dead. Fortunately, the revolver was not loaded and B escaped unhurt. A has committed the offense of murder, attempt to murder, culpable homicide not amounting to murder. A has committed no offense. Correct answer is option B, that is attempt to murder. Question number 828. A woman ran to a well stating that she would jump into the well but she was caught before she could reach. She is guilty of attempt of murder, attempt of culpable homicide, attempt to commit suicide, no offense. Here the correct answer is option D, that is no offense. Question number 829. A intending to murder B by poison purchases a poison and mixes the same with a glass of water. He gives the glass to bearer to serve B. The bearer, while approaching B, loses balance and the glass drops out of his plate. What offense A has committed? A has committed the offense of attempt to murder. Question number 830. X, a married woman, being annoyed from family quarrels, threatens her husband that she would commit suicide by falling into a nearby well. She runs towards the well, but at distance, she is stopped from committing suicide by some stranger from behind. Decide liability. X is liable for an attempt to commit suicide. X is not liable for attempt to suicide. X is liable for threatening of suicide. None of the above is correct. Here the correct answer is option B, that is X is not liable for attempt to suicide. Question number 831. Which one of the following is not an essential of an offense? Motive, punishment, intention, prohibited act. Correct answer is motive. Motive is not an essential for an offense. Question number 832. X, a boy of 22 years, sits on a cot of a sleeping girl of 19 years old and pulls down her lower clothes. Point out the correct answer. X is liable for punishment under section 378 of IPC. X is liable and punishment under section 354 of IPC. X is liable for punishment under section 509 of IPC. X is liable for punishment under all sections of enumerated above. Here the correct answer is option B, that is X is liable for punishment under section 354 of IPC. Question number 833. X abets Y to beat Z while Y was beating Z at the residence of Z. X reaches there with 3 of his friends. Y still continues to beat him. Point the correct answer. X is liable under section 109 of IPC. X is liable under section 323/34 of IPC. X is liable under section 120B of IPC. X is liable under section 114 of the IPC. Here the correct answer is option D, that is X is liable under section 114 of the IPC. Question number 834. In which of the following circumstances X cannot cause death of Y while exercising his right of private defense of property under section 103 of IPC? If Y is committing dacoity, Y is likely to cause death of X, Y is committing housebreaking by night with the dangerous weapon, Y is committing robbery. Here the correct answer is option B, that is Y is likely to cause death of X. Question number 835. A shoots at a bird in B's house in order to steal it but accidentally kills B. Point out the correct answer. A is liable for the murder of B, A is not liable for the murder of B, A is liable for the culpable homicide of B, A is not liable because it was an accident under section 80 of IPC. Here the correct answer is option C, that is A is liable for the culpable homicide of B. Question number 836. Which one of the following jurists opined that crime is an act or omission in violation of public rights? Options are Pollock, Austin, Blackstone, William Glanville. Here the correct answer is option C, that is Blackstone. Question number 837. X abets Y to commit murder of Z. Y commits murder of Z. X is liable under section 109, section 120B, section 302, section 115. Here the correct answer is option A, section 109 of IPC. Question number 838. Under which one of the following circumstances X cannot cause death of Y in exercise of his right of private defense of body under section 100 of the IPC, even if Y has created an apprehension of imminent danger to his life, of causing death, of causing robbery, of causing rape or unnatural lust, of causing grievous hurt? Here the correct answer is option B, of causing robbery. Question number 839. A entered a house to commit theft. Old lady living in the house saw the thief and shouted for help. Neighbors collected near the house and caught hold of the thief who was trying to escape. The neighbors gave the thief beatings with fists and lathis. The neighbors are liable to similar intention, common intention, unlawful assembly, conspiracy. Here the correct answer is option B, that is common intention. Question number 840. During the murder trial, it was proved that the murder was committed by 6 persons. Out of the 6 accused, identity of 2 accused persons could not be verified. Hence, the 2 accused persons were acquitted. Rest of the 4 accused persons claimed acquittal. Point out the correct answer determining liability of the 4 accused persons. Options are: shall be liable under section 302/149 of the IPC, shall be liable under section 302 or 34 of IPC, liable for negligence, shall not be liable for murder. Here the correct answer is option B, that is shall be liable under section 302 and section 334 of the IPC. Question number 841. Defense of insanity under section 84 of the IPC requires unsoundness of mind of any kind, legal insanity, medical insanity, moral insanity. Correct answer is option B, that is legal insanity. Question number 842. Point out the correct answer. A instigates B to instigate C to kill D. In pursuance of that instigation, B writes a letter to C to kill D. C does not read the letter. Therefore, A and B are liable for the abetment of murder. A is liable for abetment of murder, but B is liable for the abetment of murder. But B is not liable for abetment of murder. Option C. A is liable for abetment of murder, but B is liable for attempt to abetment of murder. Option D. None of the above is correct. Option A is correct. That is, A and B are liable for the abetment of murder. Question number 843. Point out the correct statement. A and B went to cause murder of C. A was with a spear and B was with a stick. B caught C and beat C with a stick. A did nothing while B was beating. When C fell down and became unconscious, A took him to nearby hospital for care where he died. A and B both are liable under section 302 and 34 of IPC. A is liable under section 302 of IPC, but B is liable for nothing. Option C, B is liable for murder, A is liable for abetment of murder, none of the above. Here the correct answer is option A, that is A and B both are liable for section 302 and 34 of IPC. Question number 844. X gives poisonous apple to Y with intention to cause his death. Y comes to know the fact that the apple is poisonous. Y gives that apple to a minor child for eating. Child eats that and dies. In this case, X is accused of murder and Y is accused of abetment of murder. X and Y both are accused of murder. Option C, Y has committed the offense of murder and X has not committed any offense. Option D, X is accused of attempt to murder and Y is accused of murder. Correct answer is option D, that is X is accused of attempt to murder and Y is accused of murder. Question number 845. A with the intention to commit theft instigates B to take possession of that property belongs to him. B, with that impression that the property belongs to A, takes possession of property bona fidely. In relation to the above statements, statement A is accused of abetment to commit theft and B has not committed any offense. Reason: abettor's liability is not dependent on the liability of the principal offender. Here both the statements and reasons are correct and explains A properly. Option A will be the right answer. Question number 846. Carefully read the following statements. Statement first. According to section 34 of IPC, requirement is 2 persons, whereas under section 149 IPC, requirement is of 5 persons. According to section 34 of IPC, common intention is required, whereas under section 149 IPC, common object is required. Option 3, previous consent is required under section 34 and 49 of IPC. Option 4, section 34 of IPC and section 149 of IPC constitutes a specific offense. Which of the above statement is true? Statements 1 and 2 are correct. Section 34 of IPC requires 2 persons, whereas section 149 requirement of 5 persons. And the second statement, according to section 34 of IPC, common intention is required, whereas section 149 IPC, common object is required. Question number 847. A police constable tortured a person under the order of his senior police officer. The person lost one eye because of the torture. Which of the following will be the basis of defense which can be invoked by the accused police constable? Torture was under the order of senior police officer. Torture was given because he was under the threat of losing service. Torture was given because he was under the threat of suspension from service. Torture was given because there was imminent threat to death. Here the correct answer is option A, that is torture was under the order of senior police officer. Question number 848. A child is in a house with Z which has caught fire. Neighboring people spreads a blanket to save the child. Z, in the interest of child, throws him on the blanket, but the child dies. Z has committed the offense of. Here Z has committed no offense. Question number 849. Which of the following statement is true in relation to abetment of an offense? It is not necessary that the offense abetted has been committed. This statement is the correct answer. It is not necessary that the offense abetted has been committed. Question number 850. Because of grave and sudden provocation of Z, A fires at Z, but Z does not die. A has committed the offense of option C, attempt to commit culpable homicide.